Welcome back. The Police Minister Bheki Cele is in KwaZulu-Natal as a deadline for the arrest of the former President Jacob Zuma looms at midnight tonight. Siegel, senior legal counsel for the State Capture Commission, says the date on which the former President Jacob Zuma should have handed himself over lapsed on Sunday, adding that Zuma has again taken the law into his own hands. Advocate Tembeka Ngcukaitobi argued in the Pietermaritzburg High Court yesterday that Zuma has, in the interim, again defied an order of the Constitutional Court, which last week sentenced him to 15 months in prison for contempt of the Commission. We're joined now to discuss this further and the legal road ahead. We speak to Advocate Ben Winks, who's an independent attorney, as well as Advocate Ngoako Moropene from the Lembede Tambo Pitje Chambers in Pretoria. Very good evening to you both, and thank you so much for speaking to us.
Good evening to you, Tembeka, and to your viewers.
Good evening. Thanks for having me.
Thank you so much. Advocate Ngoako, let me perhaps start with you. You said you are of the view that Mr. Zuma ought to have been arrested already for contempt of court. Why is that?
All right, thanks. If I can just perhaps indicate, if you can recall, on the 29th of June 2021, the Constitutional Court has handed down a judgment in terms of which it has made a number of orders. And the first one was that the former President Jacob Zuma must hand himself to the Correctional Services Center within 5 days, which was lapsing midnight on the 4th of July 2021. And then now, if you look at that period, has already lapsed. And then now, the other thing was that if he doesn't actually hand himself over to the Correctional Services Center, then the Minister of Police and the National Police Commissioner must, within 3 days' time, effect arrest. So I would think that immediately after he had failed to actually hand himself over to the Correctional Service Center on the 4th of July, that from the 12 midnight on that date, the police commissioner should have started the process of arresting Mr. Zuma. And to date, they have not done so. So we are now left with the last day for him to be arrested. And the reason why I'm saying that he ought to have been arrested simply because he failed to apply before the Constitutional Court for the stay or the suspension of the jurisdiction of the Constitutional Court order, which was handed down on the 29th of June.
Advocate Winks, I'd like to hear what your thoughts are. Zuma's counsel, Advocate Dalimpofu, his argument centered around the former president's case that the High Court has jurisdiction in a matter settled by the highest court in the land. And of course, he was at pains to point out that rescission and appeal are immaterial in considering this. Share your thoughts with us about this, and do you disagree with what Advocate Moropene has said on the fact that he should have been arrested already?
No, I fully agree with Ngoako. The order was quite clear that after midnight on Sunday, Mr. Zuma becomes a fugitive from justice. And at that stage, then the authorities have to take whatever steps are within their power to arrest the fugitive. The court gave them 3 days, after which they would be in actual breach, but they were entitled to and theoretically obliged to begin those steps beforehand. Now, as to the arguments about the rescission, the law is quite clear that an appeal suspends the operation of the order being appealed against, but an application for rescission does not. So it was then incumbent on Mr. Zuma to apply to the same court for a rescission, for a suspension or a stay of the order pending the outcome of the rescission application. He could have done that very easily with a Part A, Part B application to the Constitutional Court. It's frankly baffling why his legal team decided to go to the High Court with the stay of execution application. It simply makes no sense.
Is it because, I mean, we've heard several times by both councils that, including the Helen Suzma Foundation, their legal representative, that this is untested ground. And I'll start with you first, Advocate Winks. So the issue around jurisdiction, the legal counsel for Mr. Zuma, Advocate Mpofu, said attempted recourse of Section 172 of the Constitution to make the case that the High Court had exclusive jurisdiction in a constitutional challenge. So I think for us as laymen, we are confused because we're often told that the Constitutional Court is the apex court, meaning that it has final jurisdiction. Walk us through this.
Yes, I think what he's trying to say is that where you're bringing a constitutional challenge to some kind of legislation, you should start in the High Court. But that's not an absolute rule. Firstly, you can go direct access to the Constitutional Court in an appropriate case, and this would undoubtedly be an appropriate case. But whether they're bringing a constitutional challenge, they're challenging in Part B the constitutionality of the Criminal Procedure Act, has nothing to do with the stay of execution application. That stay of execution application has to be brought in the court whose order they are seeking to stay, because a lower court doesn't have the jurisdiction, and they were unable to point to any authority to suggest that a lower court has jurisdiction to stay the execution of a higher court's order.
Your thoughts, Advocate Moropene, and just because we are running out of time, I'm trying to cover as much ground as possible. And also then just please then speak to us about the effects, if any, of the former president's public statements denouncing the very idea of his arrest, if that would be considered.
Yes, I think the statement by the former president will still be considered by the Constitutional Court when determining the pending decision of judgment application. You would recall that at the time when the State Capture Commission and Mr. Zuma were required to appear before the Constitutional Court in respect of his failure to appear before the State Capture Commission, and also when there was an application for him to be declared contemptuous or his conduct to be declared to be in contempt of court, Mr. Zuma, instead of then filing an application to oppose the application, in fact, the answering affidavit, he went on public attacking the same court on the basis that it is against his conscience and therefore he cannot appear before the Constitutional Court judges that seem to be impartial. One of those issues could have to be taken into account as someone who is actually disrespecting the rule of law. He failed to appear before the Constitutional Court to advance his own reasons why he should not be arrested and why he should not be found to be in contempt of court. So, in fact, these public statements are now worsening the situation. Although the court will have to confine itself to the facts of the case and the evidence before it, in this respect on the rescission application, it will have to consider the kind of the part that they're dealing with, because if you look at the requirements for contempt, one will have to certify the fact that there was an application and there was an order which was made, which he failed to comply with, and which his non-compliance was done in malified and willfully so. Now, if you look at the requirements for a rescission of judgment, he will have to give a reasonable explanation of his default. He has indicated that I do not want to participate before the Constitutional Court. And those issues has announced in a public statement when in fact he failed to announce those issues in his own answering affidavit. Now, the second issue is required to also demonstrate absence of his willfulness. There's no explanation that he can give. Okay. He indicated that I don't want to participate. So the third one is the issue about the bona fide defense that he will need to advance, that he has got a bona fide defense which is done solely for the purpose of advancing his own interest, but not for the sake of delaying the final determination of the matter.
Advocate
so
Winks,
the public...
Let me just come to you. Advocate Winks, the Commission itself arguing that Mr. Zuma's last-ditch attempts, as they call it, to avoid prison is in itself or in themselves constitutional further abuse of the legal process. What are your thoughts around this? Is it abuse of legal process, or is it simply one exercising their constitutional rights?
Well, an abusive process can be found where somebody is using a court process in a manner that's frivolous, vexatious, malicious, or in some other way improper. Now, what they've alleged in answer to the Constitutional Court rescission application is that Mr. Zuma has approached the court with a number of falsehoods. Now, if someone were to approach a court with allegations under oath that then become demonstrably false, or that for any other reason it is vexatious and it's designed to use the court for improper purposes or use the court process for improper purposes, that then would be found to be an abusive court. And what the court would do is then it would not only reject the application, but likely also grant punitive costs.
Okay, I'm going to just get a final word from you both. I'll start with you, Advocate Winks. There was also an argument raised by Advocate Mpofu, that of the balance of convenience test. What is this, and how does it relate to stay the arrest order?
So, yeah, balance of convenience is a consideration that is taken into account when deciding whether to grant an interim interdict. It's one factor to be considered, where you say that, well, the one party stands to be prejudiced more than the other if the order is granted or not granted. And he says, well, what harm is there if you give us, another few. He doesn't indicate whether it's days or months or years, and if it's pending the constitutional challenge, that would be probably at least 2 years to go through the appeals process. So he's asking for a stay of an indefinite period up to perhaps 2 years, but he says, what harm does it do? And the counter argument is that it harms public confidence in the courts and the rule of law. So that's the debate around balance of convenience, is who stands to suffer more.
Advocate Moropene, just your word on this, final word of this, what Advocate Winks has just explained, balancing this balance of convenience test against public interest.
I think, if I can put it bluntly, I think with all due respect, Advocate Mpofu got it wrong, because that is not necessarily the test that one needs to apply to determine whether or not it can be granted a stay for the execution of the order of the court. That is an ordinary requirement for one to satisfy the requirement for an interdict. So he failed to locate these specific, relevant and important requirements that need to be satisfied for one to get a stay to be granted. The first one being that a court will have to, then there's a case law in the Shakespeare versus Pap versus Panzane, which says a court will grant a stay of execution where real and substantial justice requires it, or where injustice would otherwise result. Now, the second issue is that it will have to look whether or not there will be an irreparable harm between the applicant and the respondent. In this case, it will have to exercise a balancing act. It will have to strike a balance between the public interest insofar as it relates to the work that State Capture Commission needs to do, as well as against the private interest, which is the rights claimed by Mr. Jacob Zuma. Then the third requirement that they need to check is whether the court must satisfy that the applicant has a well-grounded apprehension that the execution is taking place at the instance of the respondent. So to go to the issue of saying I want to talk about the issue of balance of convenience to convince the court to grant a stay, it was completely misplaced. And the worst of them all was to take the matter to the higher court to decide on the stay of the execution of the court order in the Constitutional Court. And
the judge wrapping up proceedings yesterday by saying, Judge Nguni stressing that his primary decision needs to be based on his jurisdictional right to suspend an order of the Concord. So that decision will be announced Friday at 11:30 a.m.